brief introduction on the law of retrenchment in Malaysia. First, I would like to speak about retrenchment benefit. What is retrenchment benefit? Is actually compensation that an aggrieved employee is entitled to receive upon retrenchment by the employer. So who is entitled to receive? This depends whether the employee concerned fall within the purview of Employment Act 1955. If he or she fall within the purview of Employment Act 1955, i.e. if we look at Schedule 1 of the Act, which says that the employee earns wages 2,000 or below, or someone who is a manual worker, then he or she is automatically entitled to receive retrenchment benefits despite it is not stated in their contract of employment entered with the employer. However, if an employee who earns more than 2,000 and is not a manual worker, he or she is not entitled to receive retrenchment benefits unless it has been specifically stated in their contract of employment. So that is about retrenchment benefits. What about an instance where an employee feels that the retrenchment exercise done by their employer was not made in just cause and excuse? In that instance, that the employee in concern may proceed to lodge a complaint in the Jabatan Perhubungan Perusahaan within 60 days on the said ground. So how about a scenario where an employee who is entitled to receive retrenchment benefit also feels that the retrenchment exercise was not done in a good faith? Then in that scenario, the employee is advised or suggested to proceed to lodge a complaint in the Jabatan Perhubungan Perusahaan instead of Pejabat Tenaga Kerja, as the compensation that they can claim is higher compared to the compensation that they are entitled to claim the Jabatan Perhubungan Perusahaan, despite the fact that the main remedy that is allowed to be claimed in the Jabatan Perhubungan Perusahaan is reinstatement. So in that kind of scenario, it is much advisable to proceed to the Jabatan Perhubungan Perusahaan. But it is notable that an employee cannot actually make a double claim, i.e. a person cannot lodge a complaint in the Jabatan Tenaga Kerja and also Jabatan Perhubungan Perusahaan. So it depends what is the aggrieved party actually would like to claim. So that is about the basic knowledge on the exercise. But I also like to say that these complaints must be made within 60 days and it must be done in the proper body. Failure to do so is fatal. The complaint will not be entertained. So basically that is about the mode of the retrenchment. What are the things that we should basically know about retrenchment is that there must be redundancy. If there is no redundancy, then the employee may always claim that the retrenchment was not done in a good and proper manner. So there are various factors to be seen besides that, whether the code of practice was properly complied, whether the foreigners was actually retrenched first, and all these things. So if at all there are any issue on retrenchment, lots of laws that actually able to assist the aggrieved party in Malaysia.